Good afternoon, everyone. My name is Daniz. I'm a fourth-year common law student, and I'm here to present to you a journey through the fascinating intersection between law and psychology. So today we'll challenge traditional views of how we see children's rights a very traditional way and explore why Scotland is actually leading the way in recognizing children as rights holders. For too long, the law has approached children as future adults, assuming they lack competence in actually participating in their legal and social decisions. But interdisciplinary research, so drawing from psychology, sociology, and education, challenges this outdated notion. By the end of this presentation, I hope you will see why recognizing children as rights holders is not just a legal necessity, but a social and imperative necessity. So you might be wondering, why Scotland? So Scotland is the first UK nation that incorporated the United Nations Convention on the Rights of the Child into their domestic law. What is UNCRC? What is this United Nations Convention on the Rights of the Child? So it is a legal document that has 54 colorful articles, and it covers three broad areas. We have provision, protection, and participation. So when it comes to provision, we have access to resources such as healthcare, education, and a safe living environment. We have protection rights, where it's about safeguarding children from abuse, exploitation, and discrimination, as well as participation, and that's what we're talking about today, ensuring children are heard and involved in decisions affecting their lives. So to understand where we are today, we need to look at the past. Historically, children were seen as passive dependents. Children are increasingly recognized now as active participants in their own lives through Article 12, just here, that actually allows children to participate in their decisions and actually have a right to express their views. So they do it through Article 12 that we'll actually talk about throughout the whole presentation in general. And this poses a lot of questions. So first, are courts actually listening to children, or is participation just symbolic? How do childhood sciences challenge traditional legal frameworks? To understand all of that and to answer all these questions, we need to understand what childhood sciences are. So we have childhood sciences, which is an interdisciplinary field that actually has psychology, sociology, and education. Psychology provides insights into cognitive and emotional development of the child, highlighting children's ability to express their views. We have sociology that treats children as active participants in the society, challenging traditional models of decision-making. And we also have education research that shows that children who understand their rights engage more meaningfully in legal processes. This interdisciplinary field has been crucial in shifting legal perspectives from viewing children as future adults to recognizing them as present rights holders. As we know, often decisions about children are based on what adults, parents perceive in their best interests. However, this raises a critical question. Who decides what's in the child's best interest, and should children themselves have a say in what's best in their decision? So at the heart of childhood sciences, we have the debate of beings and becomings. So we have on the left children as becomings, which is a traditional development psychology that views children as incomplete individuals on their way to adulthood. And on the right, we have children as beings, the modern sociological perspective that sees children as active agents who shape their environment and should be recognized as rights holders. This shift from becomings to beings is what today's legal and academic discourse is trying to address. As we know, legal cases and courts, they play a fundamental role in shaping how children's rights are viewed and implemented. However, there are inconsistencies in how courts apply these rights in practice. Challenges include implementation inconsistencies, filtering through adults, and judicial discretion. Implementation inconsistencies. Some judges prioritize children's voices while others rely on traditional views. We have filtering through adults which children's views are heard, but they're often interpreted by parents, judges, legal representatives, and social workers. And thirdly, we have judicial discretion, where laws might state that children's views should be considered, but how much weight is given to this right and to their say is actually unknown. I hope this reassures that why we need childhood sciences, so drawing from psychology, education, and sociology, to actually make sure that we overcome these challenges and enhance a child's experience in court. To understand better why Scotland is actually taking this progressive approach, we need to see this timeline here so I don't know how I did that. And we have this timeline that shows you from 1989 to 2024 timeline, where you can see that Scotland has taken a progressive approach by first using the 1995 Act just there, and it actually introduced consideration of children's views in legal decisions. Then later in 2006, we had an act that lowered the age of presumption from 16 to 12 years old. And later in 2020, we had an act that actually ensured that all children, regardless of their age, can express their views and actually can be heard in court. And thankfully now, we have this Incorporation Act 2024 that directly incorporates the UNCRC into Scottish family law, making all children's rights actually enforceable in court. So this law reflects Scotland's commitment to treating children as actually beings and not just becomings to adulthood. What is interesting to notice is that even though England and Scotland are both in the UK, they're taking very different approaches. We have Scotland that has incorporated the UNCRC, that actually has children's rights enforceable in court, and that gives legal duty on courts to hear children. And they actually have child welfare reporters who are trained professionals that help courts reach a decision. On the other hand, we have England that actually does not have any child welfare reporters, but they have Children and Family Court Advisory Students Support Service, where they have some trained professionals that help courts reach a decision as well, but it's often filtered by parents and social workers. And they have not incorporated the UNCRC into the domestic law, and they actually have no legal duty on courts to hear children. Isn't it fascinating to see how two jurisdictions in the same country use absolutely different approaches? This contrast shows that England is actually taking a paternalistic approach, and Scotland has made significant strides in treating children as autonomous rights holders, rather than just passive subjects of adult decisions. It's really important to speak about challenges and barriers. Despite all this legal advancements, we have some barriers that remain ensuring children's voices are truly heard and respected within the legal system. So we have adult gatekeeping. Are we empowering children, or deciding when their opinions matter is actually just symbolic? Balancing protection and participation. Legal systems prioritize children's welfare based on adult perspectives. We have tokenistic participation, where children's voices are supposedly included in legal processes, and their input often holds little weight in all decisions. And we have some structural barriers, for example, the legal language that children might not understand in court, but also we have some lack of trained professionals that are needed in court to actually help children be represented in court, but also view their decisions in proper manner. What we can see is that we are standing at a pivotal moment, and we are on the way to think about children's rights in a very different way. Courts are evolving from treating children as actual beings rather than becomings. And childhood sciences are challenging traditional legal approaches, demanding real participatory rights. And Scotland is leading the way by meaningful implementation. Still remains a challenge, with obviously some inconsistencies and barriers that we have. The legal system must not only evolve, but fully embrace the lived realities of children, ensuring that their voices shape their own futures, and not just through symbolic participation, but genuine agency, empowerment, and inclusion. This is not just a legal shift. This is a societal transformation, one that challenges us to really think what it truly means to listen to children. As a final thought, before I conclude, I would like to leave you with this question. Can law alone effectively protect children's rights, or does it really need childhood sciences to truly understand them? Thank you, and I look forward to your questions.